Oh, thank you very much.
How are you?
You have a very nice place here.
Thank you very much. Come with two advantages which are very strategic in the sale. One, when you visit the site, you're able to answer the question of accessibility, whether the property can be accessed, which is quite important because that property is useless and you cannot get access.
Welcome to the Legal Assistant. This is the show where we answer all your legal questions. And today, in our meeting or in our show, we are having a discussion with one Mr. Jasper lubeto, and he's ready. I want to introduce him. I want him to introduce himself. So, Mr. Jasper, welcome to the show. Just take a minute and just introduce yourself to us so that you can be able to get to know who is Mr. Jasper lubeto.
Thank you very much, Alicia, for inviting me to the Legal Assistant. My name is Jasper lubeto. I'm an advocate of the High Court of Kenya, and I'm a practitioner dealing including in conveyancing. I also lecture the unit of conveyancing law and practice at one of the universities in Kenya.
Okay. Thank you, Mr. Jasper. As I was just going through your profile, I learned that you've also authored a book. Maybe you can just tell us something a bit about the book and show us the book and get to know.
Certainly, thank you very much. When I was doing my LLM, I did some research around agricultural land investments contracts, which actually deal with leasing of agricultural land in Kenya. So it's a land in Africa, sub-Saharan Africa generally. And the university was grateful enough to have it published as a book. And that is part of my contribution in the conveyancing landscape in Kenya.
Wow, that's powerful. That's a very vital part of your introduction that we not leave outside. So basically, you're practicing with the TLO as the leading partner or something like that. Just putting it clear. Where's your practice?
Thank you. So we are based in Kilimani. The name of the firm is TLO Advocates LLP. We are based in Kilimani with two other branches in Lamu, and the other one in Murang'a. But generally, we practice everywhere in Kenya.
In Kenya.
Yes. Wow. Thank you.
That's very powerful. Yeah. So let's get to our discussion. Today, we are just talking about conveyancing context in Kenya and just getting to understand during this particular time of COVID, people are either forced to dispose land or there are those who are in the land business or stuff like this, and I'm sure very many people are struggling on how to get things moving and how to start getting going. Can you just shed some light and just get us into this flow?
Okay. So, in fact, the conveyancing landscape has become busier. It's becoming even busier. As you suggested, because of COVID-19, a lot of businesses and even individuals are facing cash flow challenges. So they are releasing whatever assets they have, including land. And of course, a lot of businesses are also taking out borrowings in banks. And this then comes with the need to collateralize, and therefore they are getting into a lot of charges. Banks, and unfortunately, there are also a lot of defaults. So banks are being forced again to auction these properties. And as you might know, a few Kenyans have also had the opportunity to make money even during this crisis. And therefore they're also making purchases. And land, as they say, is the only asset that then has the capacity to appreciate. So then their first port of landing is to purchase property. And government is alive to that. In fact, one of the leading sources of revenue for government is on stamp duty for land transactions and also on capital gains. So in that realization, and to also make Kenya improve the ease of doing business in Kenya, the Lands Ministry is at the forefront of improving the quality and nature of transactions. And now we're even moving online. As you might know, Nairobi is now fully online. And other registries are also trying to catch up. Wow. So yeah, the landscape is very busy.
It's very busy.
And this is the best time to be in this space.
Wow. Thank you very much, Mr. Jasper. Now, I want to dispose, being that I'm the seller during this particular time. Now, being a conveyancing practitioner, advise me where to start and how I can be able to navigate and what are the do's and the don'ts and where to move in from. I've got the land. How do I move?
Good. And the question on a seller's perspective is usually the easier one to answer, really, because the seller usually has the land and they intend to then sell this land. So in terms of advice to a seller, I think the main sticking point usually is the payment structure, because the seller wants the confidence that his or her money will actually reach their pocket. And how do you do this? You do this by then engaging counsel like us to advise on the best way to go about it. And I could say a lot about this, but let me just answer that. For a seller, the most important thing as a seller's advocate, by way of advice, is to make sure that the selling, the documentation for the land on sale is proper and valid. And secondly, to take care of the seller's interest as far as the payment structure is concerned. I know by way of the LSK conditions of sale released in 2015, the advice has been that you need to receive a 10% deposit. Then as a seller, you gather these completion documents, and it is only after that then you get your balance of the purchase price, usually the 90% of the purchase price. But also it's allowed within those parties, if they agree, to rearrange or agree on a different percentage in terms of the purchase price.
So, Mr. Lubeto, can you take us briefly on the issue of the client, maybe now being the pre-contractual stage, having a meeting with the client? What happens? What do I even need to carry? What are the legal requirements that I need to meet?
Okay, good. So then that now takes me into the bigger discussion of how a conveyancing cycle goes.
Yes.
And just for clarity, I would want to say that we can split it into 3 stages.
Yes.
The pre-contractual stage, the contractual stage, and the post-contractual stage. And for better context, it's also good to introduce the parties involved in a conveyancing transaction, because most of the time this seller, or as we like to refer to them, the vendor, will usually have engaged an agent to source for purchases for the land.
Okay.
And after they have gotten these purchases, that is when they will walk to your office and say, look, Wakili, I want you to represent me in this matter. So then the question then arises, if you need advocates, how many advocates do you need? And it's always proper that each party have their advocates, so that the advocates take care of each of their interests. But for purposes of this discussion, then I will be able to shed light both with the perspective of the vendor's advocate and the purchaser's advocate. So from a vendor's advocate perspective, at the pre-contractual stage, really your work is to make sure that the documents of ownership and the identity documents of the vendor are in order. So you will of course do a casual perusal, just look at the title, and from practice, you are able to tell whether that title is original.
It's original.
It's on the authenticity, and where you feel like the authenticity is in question, then it's advisable to even peruse the actual file.
And maybe just to cut you short,
sir,
on the issue of the authenticity of the title. What do you really look out for in a title to be sure that this title is authentic?
There are a lot of things to look at, and it's one of the most confusing things to vendors, both vendors and even purchasers,
yes.
Because we have a multiplicity of regimes currently in place. You might know we still have the Registration of Lands Act, Registration of Titles Act, Government Lands Act, and all of those 3 statutes, much as they have been repealed, their underlying titles are still operative. So again, identification of those titles become a problem, because some clients will say, I want a title that will reflect my name. And you tell them, no. If it is an RLA title, sure, we will surrender this title and get a title in your name. But if it is on those other 2 regimes, the GLA, in fact, the title of ownership is the sale agreement, what we call the conveyance itself. And for the RTA, then we have this certificate of lease. And most of the certificate of leases, we will only be doing endorsements. So I think really, there's no one an answer that can fit all those variations in terms of what a title looks like. But
depends on.
And I think that's also where we earn our keep. Because we know when we see a title, we can tell from different parameters. But maybe the examples I could give you is fine. If it's an RLA, then I will expect this RLA to be identified to one of the registries in the country. If it's an RTA, then I will expect it to be originating from the central registry at Ardhi House, Nairobi, and that kind of thing. We will be very specific to also see what is the lease period. If you see an RTA title with a lease period that is below 99 years, then you must now start checking further, because ordinarily the 99 years is the default position. I know counties like Kiambu have started reducing those years, but those are some of the things to look at in terms of authenticity of title. Do you have the signature and stamp of the registrar upon registration? Okay. Do you have the encumbrance section, the section that will show whether the property is encumbered in any way? Do you have a clear proprietorship section with entries on each and every in a particular land, and so on and so forth?
Okay. Now, maybe just getting back to now our discussion, we are at the pre-contractual stage.
Yeah.
You are able to do your due diligence.
Yeah.
Is there anything else that we need to know after the due diligence? We at the pre-contractual stage.
So okay, thank you. There is one bit that we a little bit skipped when we were talking of due diligence from the perspective of the vendor.
Yes.
Due diligence from the perspective of the purchaser is actually where the rubber actually meets the road. Because you have to confirm and authenticate to the client that this transaction is actually live. And there are different parameters and different approaches you can take. You can do it by a casual search, undertake a postal search of the title of the lands registry. You can go over and above and also peruse even the maps at survey records to confirm the existence of this particular title, to confirm its boundaries, to confirm its size, and so on and so forth. You can move beyond that and also do an inspection, a physical inspection of the property. We have had cases where people have bought properties that do not exist on the ground, and they have very serious advocates who have represented them. So it is usually also advisable as counsel to take your time and visit the site, confirm that this is actually the site. And for one reason or another you are in doubt, it's important then to be accompanied even by a surveyor, because they're the ones who have the technical know-how to look at the longitudes, latitudes, and pitch of the ground. And another advantage, two other advantages that come with visiting the site. One, you're able to answer the question of accessibility, whether the property can be accessed, which is quite important because that property is useless if you cannot get access to it. And two, when you conduct a site visit, you are able to also speak to the neighbors and basically the community around there. If you like, you can have a conversation with the assistant chief, if you can talk to the local administrators and so on and so forth, and they will tell you. They know which properties have problems, which properties do not have problems. The problems could be a myriad of issues, a contest as to the right boundary on the property, ongoing litigation, that this property is actually a subject of litigation, claims by other parties. When you go to the site and you find there is a signage, this is private property belonging to so and so and so on. And so on and so forth.
But this land is not for sale.
This land, that kind of thing. So that's why then site visits become very important. And they are not exhaustive in themselves. They need to be conducted in addition to other due diligence parameters. Yeah.
Now we are through with our due diligence at the pre-contractual stage. Is there any other thing we need to do before we move to stage 2, the contractual stage?
As an advocate, I would always advise you do a due diligence report. And this has to be written because this is where your client might come back to you and say, look, Bwana Wakili, you never told me this. So it's important to capture in the due diligence report what are the risks that you identified during your due diligence. And out of your risks, what are the mitigation measures that you're advising. Then in your due diligence report, you should also always put a recommendation that I would recommend we proceed with the sale, or I would recommend we not proceed with the sale, and for what reasons. After that, then now you're as good as going into the next stage.
Now, before we move to the next stage, what is this one main important reason why it's important that you do the pre-contractual process as an advocate and to me as the vendor?
As a vendor, due diligence is not necessarily a big issue. It is a big issue for the purchaser because the purchaser wants to acquire interest in this property.
Okay.
And out of acquiring this interest, the purchaser is paying a consideration, a fee for purchase of this property. So really there is a lot at stake because you want interest and you want to enjoy this interest to the exclusion of all members of of the public. Therefore, due diligence becomes very important because it is your opportunity to know whether this property is a candidate for sale. And you need to read that together with the principle, the common law doctrine, the so-called purchaser for value without notice. When the question will be determined whether you are a purchaser for value without notice, it will turn on the nature of due diligence you did. So if your proper due diligence did not reveal any underlying fraud, any underlying defect, then the courts have done that several times, even up to the Court of Appeal level, they have endorsed and given property rights, interest in property, even where there are underlying issues, as long as those issues could not have been revealed by basic due diligence.
Due diligence. Wow. So basically, to you as the buyer, it's very important for you. You've just learned that it's very important for you to make sure that you engage in the due diligence. The pre-contractual stage is very important for you so that you get to know. Don't begin buying the land and then you realize you've made the payment and the land does not belong to this person who claims to be the owner, or there are issues with the land. It's important for you. Now, as you're just moving to the next stage, now we've done all this and the land is ripe for sale. What happens next?
So the next stage then is for you what we call the contractual stage. And here really is the contract. You know, the Law of Contract Act has endorsed this and states very clearly that a sale of land will not be valid unless there is a contract, which contract has to be witnessed. So that becomes very important, both for the seller and the purchaser, because for them to enjoy any rights within the context of this sale of land, or within the context of the transaction in this sale of land, then that contractual document will be very important. For the vendor, what is important in the contract is the payment terms, because really, as I've said here, the issue, the primary interest of the vendor is to get their money. So they want to know how much will I be paid, on what terms, in which currency, to which account, it will be RTGS. You know, these things which look sort of basic become very important, especially in terms of compliance and timelines. What are the timelines to be expected? What are the remedies within this contract when timelines are not met? And so on and so forth. So those are the issues to discuss in the sale agreement. For the purchaser, the most important thing the purchaser will be looking at in the sale agreement are the completion documents. What is the completion date and what are the completion documents that will be expected? Do we have an original title? When will it come in? Consents. You know, who owns this property? In this regime of spousal interests, in this regime of charges, you have charges of the property, is it encumbered? When will these encumbrances be removed out of this property? Do we need to go to the land control board if it's agricultural property? When? What are the timelines we'll use? How much time do we give the seller to undertake this, and so on and so forth? So really, this is where the meat of the transaction is undertaken, and the terms with respect to implementation of the transaction are agreed to. And once then you sign, you put ink to paper, as whether you are the seller or the purchaser, you should be aware that then there are consequences. You know, there are consequences to if you renege. You know, we have situations where vendors agree to sell property at 10 million and they sign the sale agreement. Then tomorrow, they get another prospective buyer who says they're prepared to pay 12 million. As a vendor, do I have a right to then cancel this contract? No, because you've already gotten into a contract and agreed to a certain price. So before you put ink to paper as far as this sale agreement is concerned, you need to be very satisfied with these terms that you're being tied to.
Okay. I think the contractual stage is not very cumbersome as long as the pre-contractual stage is done. Can you now take us now? We've done the contract, the sale process is done. Now, what happens the post-contractual stage?
So basically, in the post-contractual stage is where now we want to undertake the registration.
Yes.
And usually the registration is preceded by the completion date. This completion date has two major things happening. One, on the completion date, we are having the vendor surrendering all the completion documents to the purchaser. And on the other hand, we are having the purchaser releasing the balance of the purchase price. And it is on this completion date that is also the ideal date for the purchaser to take actual possession of the property. Then of course one of the major completion document being the transfer. Then now it is now the owners of the purchaser's advocate now to move the process for registration. And registration is often preceded by valuation. So you undertake a valuation, you know what amount has been assessed by the Ministry of Lands, pay that stamp duty amount. Once you pay the stamp duty amount, then you lodge these documents for registration. Once you lodge them for registration, then as council, it is your duty again to follow up and pick up the new title. Whether it's a new title in the name of the vendor or the purchaser, or it's the old title with an endorsement of the name of the purchaser on that particular title. Then really the meat in the post-contractual stage is done. And the only other thing I would advise usually is to do a post-registration search. Just take a search from a third-party perspective and see whether now the name of the purchaser has been entered into the title. And that then marks
the end of the process. Now, I wanted to ask, is it appropriate that you conduct the search to establish the name? Is it after the contractual stage or at the due diligence?
Good question. So you actually do that twice. At the due diligence stage, that is at the pre-contractual stage, you will be taking out a search to confirm if the property, the title, is in the name of the seller, the name of the vendor who is selling. At the post-contractual stage, as the purchaser's advocate, you will be conducting the search to confirm if the name of your purchaser, your client, the purchaser, has now been entered into the title and it's as good as within the land registration systems.
Yeah. Now, thank you very much. Now, I just want to maybe some clarification.
Yeah.
Post-contractual stage.
Yeah.
How long should these timelines or normal circumstances? I understand the technicalities of organization, but on the normal circumstance, how long should this process take? I have made the payment for the land, I've done the payment, we have signed the agreement, now transferring this land from my name to the other person.
So at the post-contractual stage, as long as the completion date has been undertaken, it means as far as the vendor is concerned, they are now out of the scene because they have handed over all completion documents and they have received their balance of the purchase price. Now the relationship is now between the advocate and the purchaser. And really the role of the advocate is to fast-track valuation, ensure the valuation is conducted in time. Of course, in the old days, we will have a lot of challenges because valuers will take a lot of time before they come to the site. But now we have reforms where the Ministry of Lands has now allowed the use of private valuers to even undertake these valuations. So again, I know by the charter, it is said that this process can take as less as 12 days. But the reality is a little bit different, and it depends on which registry you're engaging. Some registries are idle, there are registries, without, I do not want to sound discriminatory, but if you go to some registries, you'll find in a year they have less than 50 transactions. If you go to Ardhi House, Nairobi registry itself, on the day, every day, they are registering over 50 transactions are being lodged. So of course, you do not expect these timelines to be cast in stone and to be the same. And I would say that in terms of timelines, it depends. It depends, but eventually I would say what is reasonable is what applies. So that is why in the LSK conditions we have the 90 days. And then post 90 days, then you can give and take another 1 month for the transaction to close.
If maybe there's technicalities, the seller has done everything and now you are having technicalities and you realize the technicalities in transferring this land arising from the seller's maybe confusion or some mistakes. Could there be maybe other remedy, or is there that time that you can take this issue to court or where?
Certainly there are remedies, and that is why the quality of your sale agreement really matters. Because in the sale agreement we usually have a warranties clause. And those warranties clauses, this is the time to invoke them. If you then meet some challenges in terms of making the registration, or for one reason or another there are mistakes, there are things of omission that they were conducted by the seller and they were not discovered at the due diligence stage. Remember, some of these issues should be picked out in the due diligence stage. You know, a question of whether a title should be rectified. That is a question that I have grappled with before, where we are having a title in the name of a company, but the name of the company, as it's indicated in the title, is missing some letters. As far as we're concerned, that's not the company.
That's not the company.
So it calls for rectification. So if the advocate did not realize it in good faith during that time, then they can invoke the warranties clause and say, you warranted that this transaction will go through because of A, B, and C. Please now come and correct that. And a seller, even though they have taken their money and exited from the scene, still has that responsibility, especially where these technicalities are arising from an act of omission or commission on their part.
Okay, wow, that's very wonderful. As we finish, can you just maybe summarizing all these things in just 1 minute, like in this stage, this is what happens, so that someone who maybe was not able to follow the whole discussion can be able to capture all these in like just 3 minutes, the whole process from the pre-contractual to the post-contractual.
Okay, thank you. So first of all, the vendor is the one to put their property out there for sale by way of whatever, do an advert or commission agents to sell your property. Then of course you'll have a meeting between the vendor and the purchaser and agree on the basic terms that, okay, fine, subject to due diligence, we can buy this property at this amount and we'll pay using this structure, and out of it we will get a title. Then, of course, the purchaser needs to now engage counsel to conduct a thorough due diligence in terms of authenticating the title, authenticating the identity of the vendor who's selling this property. Subsequent to that, then they then sit together and do a sale agreement, of course guided by counsel, whether it's counsel from both vendor and purchaser point of view. Do a sale agreement, sign the sale agreement. The sale agreement should be very clear. What are the payment terms? What are the timelines? What are the completion documents that are expected? The outgoings in terms of the fees that are in place. Even the legal fees should be discussed within the context of the sale agreement. Then, of course, the vendor then has the honors to assemble these completion documents as the purchaser also assembles the balance of the purchase price. Then on the completion date, let them do a simultaneous exchange. Take the completion documents, the seller, the vendor then takes the balance of the purchase price. Then the advocate, usually of the purchaser now, then moves to lodge the registration at the lands registry. Of course, starting with valuation, payment of stamp duty, and then after payment of stamp duty, then causing the registration. One thing that we left along the lines is capital gains tax. Maybe you allow me to say a few things about that, is that now it is expected that as a seller, as a vendor, you also declare capital gains tax. And it's a self-assessment system. So you move into the iTax system and make a declaration in terms of how much did you pay, how much did you purchase this property for, what were the incidentals, have you improved the property, have you spent money in the improvement of the property, what were the legal costs and so on and so forth, vis-a-vis how much you sold it. Then we get a figure. If it's positive, then you have to declare that capital gains and have it paid. So basically that is the conveyancing process 101, I would say.
Wow. Thank you very much. I'm sure you've heard it from the experts, and it's now upon you to choose whether you will choose do the right procedure, do the right diligence, and make sure that you have the right transaction. After all, the most important thing is first, do the right process. Number two, have the right people involved. If you don't do that, please don't complain. You've heard it from the legal assistants, and this is very important for you. Now, Wakili, as we close this segment, I've got two questions that are arising from the discussions we've had. Number one, I want to sell land that is, I've used the title for loan. What happens?
So usually that means the property has a charge on it.
Yes.
And once you have a property with a charge, then the bank has what we call an overriding interest in that property.
Okay.
And unfortunately, you cannot then sell that property unless you first of all seek to discharge that property.
Okay.
The only other way you can do it is to have the bank also as a party to this sale, where it is very clear that as this sale will take place, part of the purchase price shall be used to offset the monies owed to the bank. But there is no registration that will take place until and unless the property has been discharged.
Yes. So basically, if I'm to sell this land, then I have to involve the bank.
Correct.
Thank you very much. Question 2.
Yep.
I bought a land, you're in a transaction process. We've done the deposit, and then along the way, the vendor gets a better buyer, and now he's rejected the remaining part of the money, and he wants to pull out. What happens, or what do we do?
Again, now that depends on the quality of your sale agreement. Usually, for us, when we are advising purchasers, is to include a right to specific performance. So when the vendor, for reasons that are not agreeable, including the reason that he's gotten a better deal, purports to renege from the transaction, then you can move forward to court and seek for an order of specific performance. And they have been given before. They have been given before, and they can be given again by the courts of law. Only that is usually advisable as a purchaser not to also be too litigious in these kind of transactions, because conveyancing transactions as they were are generally non-contentious. So where the vendor insists that they want to renege and they want to terminate the contract, then usually you also do your cost-benefit analysis and you say, fine, give me back my money. I look for another alternative property. In any case, we have over 480,000 square kilometers in Kenya.
In Kenya.
Yeah.
Thank you very much, Okili.
Thank you.
Now, that was a very enlightening session and a very powerful engagement. How do we get you? How do we get you if you want to transact with you, or if I want to ask you more questions?
So we are TLO. Let me just pull my business card here. TLO Advocates LLP, and you can get us here at Kilimani. This is our Kilimani office. I don't know whether this can be seen, but this is our address. Maybe I also say you can also get us through email, info@tlo law.co.ke, and we are available even online. When you Google us, you will find our address, and we're always very happy to engage and assist parties with their transactions.
Wow. Thank you very much, Counsel.
Thank you. Thank you very much for having me in your show. This is a very good show, and keep it up.
Thank you.
Thank you.
So, till next time. Keep watching, keep following, and we'd love you to follow us on our YouTube channel, on our Facebook page, and even our Twitter account. All is the legal assistant. That's where you find all your legal questions answered. I'm sure you're looking for more. Please get in touch with Okili and just ask more questions. And if you want to engage us, please, our contacts are running down there. Thank you very much. It's me, yours, Winger Road. Till next time. Thank you.